sister. And we have written a great number of articles together over the years relating to the death penalty in the United States, and we're working on a book project. And this piece of the project has to do with what constitutionalism more generally can learn from the experience of capital punishment in the United States. So it seemed, it's part of the book, and it seemed perfect for this day's discussion on constitutionalism. Because the death penalty it's frequently remarked that the United States and the death penalty, the United States' retention of the death penalty is exceptional, and it's an example of America's political and cultural exceptionalism. But our point in this paper, my point in this paper, is that the death penalty is an example of American exceptionalism in a less commented, less noticed way, that is legal, institutional, and constitutional exceptionalism, because the United States has not merely retained the death penalty, along with countries like China, Iraq, Iran, or some states have abolished it, like our European peers, but rather the United States as a country has subjected the death penalty to a 40-plus year experiment, as the court has called it, in top-down constitutional regulation of the practice of capital punishment. At the same time that the U.S. Supreme Court has engaged in constitutional regulation of a number of other hot, contested social issues, whether it has to do with the desegregation of schools, abortion rights, affirmative action, gay marriage, the criminal justice system more generally. In the past 50 years, there's really been an explosion of constitutional regulation of these issues. And we think that some of the dynamics that we observe by our deep down drilling, as Elizabeth calls it, into the death penalty context can offer a kind of insight into recurring dynamics with regard to this particular kind of constitutional intervention. So I've chosen 3 examples of recurring dynamics from the death penalty context, and for each one of these 3 examples, I try to show how one can see the same dynamic at work in some other context. So one dynamic has to do with the interplay between substance and procedure, between substantive constitutional regulation and procedural constitutional regulation. And one thing that is much remarked about the Supreme Court's approach both to capital punishment and to the criminal justice system more generally, the Supreme Court's constitutional revolution and criminal procedure that took place mostly in the 1960s, is that it was largely procedural in focus. Instead of asking what might be wrong with the death penalty in terms of who was receiving it, for what crimes, in what patterns, the Supreme Court instead focused on the mechanics by which it was imposed. And in the foundational cases, which briefly abolished the death penalty in the United States, the Supreme Court said what's really wrong with the death penalty is its failure to guide sentencer discretion, so the failure of procedure. And most of the solution that the court engaged in was similarly procedural. Similarly, during the criminal justice revolution of the 1960s, instead of saying, which many people take to be the motivation for the Supreme Court's engagement with criminal procedure in the 1960s, look at how the criminal justice system is being used in the South. It's oppressive. It was used as a weapon in the civil rights movement against political protesters. It's used disproportionately and unfairly against the poor and against minorities. Instead, the Supreme Court's intervention was virtually entirely procedural. Let's provide counsel, Miranda warnings, suppress unconstitutionally seized evidence, extend the right to trial by jury, instead of looking once again at who was being punished, for what crimes, by how long. As my former colleague Bill Stuntz observed, substantively, in the United States, the criminal justice system, in the past 40 years has seen an overwhelming increase in the number of those incarcerated and the length of sentences, in the disparate impact upon the poor and upon racial and ethnic minorities. The Supreme Court wasn't looking at any of that, only at procedural intervention. So one of the things we observe in the death penalty context is the way in which procedural interventions can displace substantive interventions, turn the gaze away from substantive problems, and indeed legitimate the system by purporting to have improved it procedurally rather than substantively. Indeed, it's really astounding. In another paper that you missed back at Chicago, Bernard, that Jordan and I presented at Chicago last month, we looked at the discussions of race in the Supreme Court's early death penalty cases, and we see that the Solicitor General of the United States, who at that time was Robert Bork, in these early cases litigating the death penalty, the states and the Solicitor General all said you shouldn't worry about the death penalty because you shouldn't worry about its racial disproportions because we've just created all of these shiny new rights for counsel and for juries, and so therefore we don't need to look at the actual distribution of death sentences because of all of these new procedural rights that have been granted in the 1960s. So there's a way in which proceduralism can displace and avert the gaze from substantive problems. So one sees that very, very clearly in the death penalty context, and you see it in the court's generalized interventions in criminal justice more broadly. So that's one point, the point about proceduralism displacing substantive regulation and legitimating underlying distributions by focusing on the regularity of procedural outcomes. But there's a twist to this, because writing in the 1990s, my brother Jordan and I, in our sober second thought speech that Elizabeth and I were just discussing, argued to the court that it should have focused, it could have done a better intervention in constitutionally with regard to capital punishment had it been more substantive. But the court, when we were writing, the court had just refused to invalidate under the Constitution the death sentences for people with mental retardation, or as it's now called, I don't know if you've had this language shift in France, it's not correct to say anymore mental retardation, now it's intellectual disability. So the court in 1989 had refused to engage. Similarly, the court had refused to strike down the death penalty for juvenile offenders in the same year, 1989. So we were writing in the middle of the 1990s, and we said it would have been a much better intervention had the court engaged in substantively with the death penalty, and at least that was low-hanging fruit. They should have eliminated the death penalty for these groups. Then from our mouth to the Supreme Court's ear, in the early 2000s, the Supreme Court did exactly, and not because we told them, but they did do exactly that in 2002. They declared unconstitutional the death penalty for people with intellectual disability. In 2005, they did so for juvenile offenders. And then we saw something interesting, which is once again, I think, completely generalizable, that substantive interventions can be undercut procedurally. So the Supreme Court said it is unconstitutional to execute people who have intellectual disability. And you might think that that means that we no longer execute people with intellectual disability in the United States, but that would be wrong. We do all the time, and that is because states are allowed to set up the procedures by which one decides whether someone has intellectual disability or not. And for example, Georgia sets the burden of proof beyond a reasonable doubt on the defendant. And so there is always some state psychologist who will say, oh, he doesn't have mental retardation, he doesn't have intellectual disability. In Texas, the decision is made by the sentencing jury at the moment of sentencing. So they're told, you decide what the appropriate sentence is, but if you think it should be death, you can't give it if the person has intellectual disability. Now, you also must decide whether the person has intellectual disability. You will not be surprised that the number of people whom Texas juries have found to have intellectual disability is 0. Procedure has shown to be a way of undercutting substantive rights, and we've seen a really perfect example of this is the abortion rights context in the United States, where the Supreme Court has similarly said there is a core right to terminate a pregnancy in the first trimester of pregnancy, which the court has not moved on, but states have been allowed to procedurally regulate abortion rights, and they have created things like waiting periods, tried to put notification of parents and spouses, have done a lot with the regulation of abortion clinics. That's been a big thing in Texas. So through the procedures, instead of saying we don't like abortion and we want to limit the right in some direct substantive way, the states have put many limits around what you have to do in order to access this right, which has been quite effective in limiting the substance of the right. So there's this interesting interplay between the way procedural rights can divert attention from substantive rights, but the way substantive regulation can be undermined by procedure. And so this is forever a challenge in constitutional regulation between the sort of the hot and the cold taps of trying to get the water right so that one can define and enforce some kind of substantive guarantee. So my second point had to do with the difficulty of enforcing national norms against a background of federalism. Now, this is a problem for constitutionalism even outside of a federal system like the United States, because one of the motivations for constitutional regulation is embodied in our word regulation, to make more regular, to regularize, standardize, make more uniform certain kinds of practices. But anytime a central norm comes down from the top through a court, it has to be filtered through other institutions. Courts don't have the power to enter into other bureaucratic institutions and determine their precise arrangements. Their norms have to be filtered through these institutions. And in the United States, we've seen an extraordinary difference in the way these norms for example, the capital punishment context had trouble filtering in the same way in different jurisdictions. So one of the we love stunning comparisons, and the most stunning comparison is between the state of California and the state of Texas. Now, death sentences in the United States are begun at the local level. We have localized criminal justice institutions, so individually elected district attorneys in both California and Texas decide whether they want to bring a capital charge in their jurisdictions. And it turns out, actually, in California and in Texas, they bring them at roughly the same rate, and they get sentences at roughly the same rate. People don't understand this. Texas and California sentence at the same rate and produce the same numbers of capital sentences. Nonetheless, since 1976, Texas has executed close to 600 of the 1,300 people in the United States who have been executed. California has executed 13 in the same period. So 600 versus 13. That's an extraordinary difference in the ability to translate a death sentence into executions. And this extraordinary difference is accounted for both by the way in which political elected officials, the politics and the political systems in which they're working, the court system and the due process cultures. It's just tremendously different, the kinds of review that one gets legally in Texas versus in California. And even at the state level, the governor and the ability to set execution dates and move executions along has produced this disparity. What's really stunning, we love this line, is that in California, execution is not the main cause of death on death row in California. It's not even the second leading cause of death on death row. People die more frequently of natural causes and of suicide on death row in California than they do from being executed. Just an extraordinary difference in the way that norms are filtered through state bureaucracies, political systems, systems of legal review, that reflect another example of how the kinds of challenges that constitutionalism faces. And one good, I think, example of this differential has to do with the way in which the Supreme Court's norms of desegregating schools, which began in the 1950s with Brown versus Board of Education, and in the 1960s and early 70s with the Green case and the Swan versus Charlotte Mecklenburg. The court's big cases were all had to do with desegregation in the South, but the kinds of norms that the court created had difficulty filtering, interestingly, into the North, where segregated schools were more the product of patterns of housing segregation, residential segregation, than they were of the de jure separation of the races by law. And this led to a great difficulty for the court to translate its norms about unitary school systems, which it had developed in the context of the South, to the North. And this has been one of the main reasons why the court has failed not only successfully to desegregate in the South, but also to desegregate in the North. And the translation of norms through differences in other institutions, in this case, the way school districts are set up, makes a big difference. And I'm thinking of adding a part to this paper about abortion rights as well, because the different ways that the healthcare system is set up and the way clinics are licensed, and even the rural-urban differences in terms of the distances people have to travel to access healthcare in different states has made the ability to translate norms at a very high level to make them have completely differential impact. Third, and finally, I'll wrap up here, the death penalty is taken often to be a really good example of the problem of backlash. There's a ton of literature about the difficulty of constitutional regulation in conversation with with a political system that is at a different place. And can courts ever move very far ahead of where society is politically, where the general public is politically? And many people take the death penalty to be Exhibit A in how the Supreme Court can't get out too far ahead of the people. In 1972, it says goodbye to capital punishment, huge backlash, especially in the South. In the 4 years after Furman versus Georgia in 1972, 35 states and the federal government passed new capital statutes in a period of 4 years. And the Supreme Court knew that, or decided that it couldn't maintain its abolitionist stance. And in 1976, it reauthorized capital punishment by approving some of this new generation of statutes. And that's taken to be a classic story of backlash. But I think in looking more deeply at the story, one can see certain features of how backlash works. I think one of the main defining features, and it's kind of ironic, is the court really thought that the death penalty was on its way out. In the 1960s, there was a Gallup poll in 1966. It's the only time in American history that a national poll showed more people opposed to capital punishment than in favor of it in 1966. And I think the court thought, it's the 1960s, nobody likes the death penalty. There hadn't been an execution in 5 years in the United States in 1972. They thought, no one will miss it. We'll get rid of it. It'll be gone. And when you read the language of, the majority opinions in Furman, they don't think it's temporary. They clearly think they're closing the book on a chapter. One of the lawyers who was part of the litigation effort wrote very quickly a book, wonderful book. I don't know if you've read it. It's Michael Meltzner. He was one of the LDF lawyers who was on the litigation team. He wrote a book in 1973, the year after Furman, called Cruel and Unusual: Capital Punishment and the Supreme Court. And it's a wonderful book. It tells the inside story of the litigation, and it kind of ends with, and that's how the United States ended capital punishment, the end. Well, it was a little soon to write the end of capital punishment, but it reflects, I think, many people's senses that were done, and the Supreme Court had just misread where things were. Capital punishment was much more volatile than that support for capital punishment. Crime rates were soaring in the late 1960s and early 1970s and onward until about 1990. And I think one of the things that the death penalty story illustrates is how important it is and how difficult it can be to gauge where the public stands at any given moment. Sometimes, though, you can tell. And I think this is an example where the gay marriage context is very different. There is a stark generational divide about gay rights and homosexuality more generally. And so the Supreme Court, I think, will be quicker to intervene here in gay marriage because it has a pretty good sense of where the future is going politically with this issue in a way that is very different, where the death penalty provides, I think, a strong contrast. Two, so the Supreme Court creates fodder, creates incentives for politicians. And politicians starting in 1968, but going throughout the 70s and the 80s, used the rising crime rates and the Supreme Court's interventions in criminal justice as a kind of political platform. The law and order platforms from the 1960s really through the 90s provided a great backdrop for politicians running against the court. Similarly, we can see the early interventions in gay marriage. 10 years ago, in 2003 in Massachusetts, the Supreme Court in my state was the first Supreme Court to declare a constitutional right of gay marriage. On the 50th anniversary of Brown versus Board of Education, they deliberately handed down their opinion in Goodridge versus Commonwealth, and we are the first state to have constitutionalized gay marriage. Many people say that cost the Democrats the 2004 election because 11 states or 13 states, I forget, I have the number in my paper, had anti-gay marriage initiatives on the ballot to bring out conservative voters to the polls in 2004. So that's a nice complement to the story of the law and order platform that initially gay marriage played that galvanizing role, allowed politicians to run against it and to run against court intervention. I'd say that's changed now, but that's another dynamic of backlash and the dance of politics between a court and the public that one sees in the capital punishment context. I conclude my paper by saying that one can learn something from each one of these interventions about the future. So the court's substantive intervention in declaring the death penalty unconstitutional for offenders with intellectual disability and juveniles has created a doctrinal framework. The things that the court looks at for its substantive intervention, I think, has provided a blueprint for constitutional abolition should the court want to go there. On the differential between California and Texas, I think constitutional abolitionists have to love California because it's the most dysfunctional death penalty state in the United States, and it's Exhibit A in the constitutional case that the death penalty, as applied in many places in the United States, cannot possibly meet any valid penological objective given how dysfunctional and pathological its application is. So the varieties and of bureaucratic drag on the death penalty once again provide part of the constitutional case. And finally, the backlash, I think the Supreme Court today, as in the gay marriage case, would much less fear backlash for a constitutional abolition of capital punishment because it's already done 40 years of constitutional regulation. It can say, we tried to fix the death penalty, so now if we haven't fixed it and it's still not working, we need to get rid of it, and that's a more politically palatable position to take than perhaps it was in 1972. So when I was first writing about the death penalty early in my career, in the early 1990s, people would ask me, do you think that in the United States there is any possibility for nationwide abolition? And I would always say the only chance for nationwide abolition is through the Constitution, because Texas and Alabama, Mississippi, and Georgia and Louisiana, they are not going to legislatively abolish capital punishment. So the only way would be for a constitutional norm from the top. What are the chances of that? 0 is what I would have said, and did say for at least a decade. But today, having studied the death penalty in the United States and constitutionalism in the United States, I would say, I will take your money. I will say that the Supreme Court will abolish capital punishment in the United States in 20 years. So, take out your wallets. I'll take all comers. Thank you.
Thank you very much, Carol. Well, it's not a very optimistic view, but it's a long time.
Did you say not optimistic?
Yes, it's a long time.
20 years. How old are you? I'm
It's long. Okay, we'll see. We'll take the bet.
That's the optimistic view in the U.S.
Yeah.
Yes.
Okay. Elizabeth?
Yes, thank you, Florence. Just like Florence, I mean, I would feel much better if I could speak French, but I'm not going to like her as ridiculous as she was. So I'm going to speak English. It's both of us will be ridiculous. First of all, I mean, thank you very much, Bernard, for having invited me, and to Olivier too, because I assume that you work together, and so it's a pleasure and an honor. Well, I must say that when I got Bernard's invitation to participate in the panel, and when I saw that I was a commentator of Carol Steiker, Harvard Law School, expert on death penalty, having not written a single line on death penalty, oh my God. So I hurried up, and I wrote to Carol, and I said, well, why don't you take the lead on this? And I will react to your paper. And I think it worked out pretty well, because we are not in disagreement at all. The only point of difference is about the length of time it will take. You say 20, Carol, and I would say it's going to be much shorter. And I hope to be able to convince you of that. Until I read Carol's draft, I thought that she would not believe in a possible abolition of death penalty. I thought that, and I thought that this would be our point of divergence. But this is no longer the case, because, as you've heard, she projects the abolition of death penalty in 20 years, and in her drafts, she clearly writes that, and I'm quoting, the past decade and a half, the context had shifted enough that federal constitutional abolition seems possible, even probable, at 20. And this is also my opinion. Sooner or later, the death penalty will die out. Question is how. As early as 1995, Carol identified what she calls the constitutional regulation of the death penalty that forms part of what she calls American exceptionalism. So, the court has subjected the death penalty to an intensive top-down constitutional regulation, and within that regulation, as she expanded in her presentation, she identified three dynamics that are at work and in the current Supreme Court's jurisprudence on death penalty. Interplay between substance and form, the difficulty of enforcing national norms against states, rebellious states, and the problem of political backlash. The question boils to this: what role, if any, will these dynamics play in the abolition? Carroll sees, and I'm quoting, a new doctrinal structure in that framework on death penalty, new doctrinal structure that has taken shape over the past years. And in her draft, she didn't mention that in her oral presentation. I mean, maybe I missed it. But in her draft, she put heavy emphasis on proportionality. Proportionality between the crime and the sentence. And the Supreme Court said, for instance, in Kennedy, in Atkins, you cannot impose an excessive punishment on crimes. So, according to Carroll, if I read her correctly, a proportionality jurisprudence has emerged that may lead us to believe that if current trends continue for another decade, death penalty will disappear. She says again, I'm quoting, the court elaborated on its underdeveloped proportionality jurisprudence to explain what kinds of objective factors would indicate an emerging societal consensus against some form of capital punishment. Societal consensus, societal standards may play a role in the abolition of death penalty, but in my view, another approach may be taken. Death penalty, in my opinion, will be killed for ethical, for moral standards, not societal norms. The death penalty will disappear in the United States because it is contrary to human dignity. And I think that the court eventually will say so. First of all, human dignity, as a starting, human dignity has nothing to do with proportionality. I don't think that in the project of abolition of death penalty, you can capitalize, you can bank on proportionality. Proportionality calls into questions of fact. Human dignity implies questions of law. So, I'm going to focus on human dignity in the case law, the jurisprudence of the Supreme Court for more than 70 years. As you know, human dignity has stand out in Supreme Court's opinions, Supreme Court's jurisprudence, sometimes in court's opinion, more often than not in concurrence or dissenting opinions by the justices. But as a result, whether you look at it at the opinions of the court or at the separate opinions of the justices, you are facing, a long story of human dignity in Supreme Court's jurisprudence. Now, I will not go back to the origin, Rochin v. California, Trump v. Dallas, going back to Miranda v. Arizona, Furman, because I think that over the past decade, that is really my conviction. I think that over the past decade, a turning point has taken place in Supreme Court's jurisprudence. For me, my humble opinion, Brown versus Plata is the turning point. Because in that case, that had to deal with detainees, the way detainees were treated in California prisons. There was no reference to proportionality in that case. Not a single reference to proportionality. The court says, respect, and I quote, respect for that dignity, that is to say, the human dignity inherent in all persons. So respect for that dignity animates the Eighth Amendment prohibition against cruel or unusual punishment. There was, and that is quite interesting, there was a majority of 5 votes behind that. That's quite rare, quite rare. And recently, the case that I studied, more recently, is the last case, Hall versus Florida. In Hall versus Florida, May 14, I think, 2014, the court put the emphasis on human dignity even more strongly. And I'm quoting some excerpts of that opinion, all of them in a majority opinion authored by Kennedy, with the 4 liberals behind him. So I'm quoting, to enforce the Constitution protection of human dignity, this court looks to the evolving standards of decency that mark the progress of the maturing society. But to enforce the Constitution's protection of human dignity. So the Constitution protects human dignity. We are miles away from the nebulous standard of Rochin versus California in Douglas and Black opinions in 1954. Right? Second point. The Eighth Amendment's protection of dignity reflects the nation we have been, the nation we are, and the nation we aspire to be. That's pretty strong language. That is pretty strong language. Third, if the states were to have complete autonomy to define intellectual disability, the Eighth Amendment protection of human dignity would not become a reality. Eighth Amendment protection of human dignity would not become a reality. Fourth, the action of the states and the precedents of this court gives us essential instruction, but the inquiry, our inquiry, must go further. That exercise of independent judgment, we are far away from the backlash of public opinion. Independent judgment is the court's judicial duty. And fifth, last, Florida's law contravenes our nation's commitment to dignity and its duty to teach human decency as the mark of a civilized world. The states are laboratories for experimentation, but those experiments may not deny the basic dignity the Constitution protects. Well, okay, if words make sense, after this, I no longer see how death penalty can fall within the 4 squares of the federal Constitution. So, in my opinion, the days of the death penalty are numbered in the United States. Now, so we are totally in agreement, Carolina, is this. And the point is, how long will it take? How long will it take? I think the answer has to be found in the opposition between Kennedy's opinion and Alito's dissent. For in his dissent, Justice Alito, of course, does not say a word on human dignity. He does not mention. You cannot oppose human dignity. I noticed actually the point in dissent, Scalia's dissent in Brown versus Plato. Scalia was, of course, opposed to Kennedy in Brown versus Plato. He did not recognize. He did not want to recognize any dignity in detainees, and he pressed that aside as totally inappropriate. Did not even mention it, but he said what the Constitution prohibits is to treat detainees indecently, and to give them indecent treatment. He did not say that they have to respect dignity. So Alito, runs along the same lines. He does not go against dignity. In fact, he does not say a word about it. But he says this, and then you understand that the opposition between the majority and the minority. He says, whether a punishment is cruel and unusual depends on currently prevailing societal norms. So we are back to the societal standards that Carol mentioned in her paper. And further down, still Alito speaking. Even if it were appropriate for us to look beyond the evidence of societal standards, meaning it's not appropriate to go beyond societal standards. Even in that case, I could not conclude that Florida's method is unconstitutional. So here we are. And this is, in fact, the alternative that the court is facing, in my opinion. Now, of course, it may be a little bit simplistic. I know that the American lawyers, procedural oriented as they are, say, you cannot say that, it's too simplistic. Two parts. It's in two parts. You have an opposition between two possibilities. Either the court will go with societal norms, which is Carol's approach, or it will go through ethical, moral standards. This is my opinion. And this is my opinion, not because I think that this is the way the court should do it, but because this is the way the court has already done it in certain occasions. I think that Brown v. Board of Education was not based on societal norms. Brown v. Board of Education had nothing to do with what the public opinion had to say. For me, the most important statement in Brown is separate facilities are inherently unequal. Inherently. You don't put anything in balance. White, black schools, no. They are inherently unequal. And I believe that for the death penalty, you can apply exactly the same reason. Put a balance between those who are mentally disabled and those who are juveniles and those who are full adults. And you balance you cannot go through this because the court will fall into dispute in the long term doing that kind of balancing game. It has to have a standard of morality.
It has to hold to a lodestar. It has to guide a society. This is its role, actually. I'm referring to this wonderful piece by Aaron Barak in the Harvard Law Review, The Role of the Supreme Court. Closing the gap between society and the law and protecting democracy. That's a judge. That's a character. I hope that the court has this courage to eventually say that death penalty is inherently inhuman. Will it say so? Will it have to wait for 20 years? What does it mean to say so? And here, French education will come up again, raise up. The court needs political support. So I think that the court is waiting for the appropriate political circumstances to say so. What do I mean by appropriate circumstances? I mean a political election. I mean a presidential election. I mean a candidate who will lead as a statesman or a stateswoman to our American people to health coverage. Yes, we can. Abolition of death penalty next time. Thank you.
Well, thank you very much, both of you. So we start the discussion for half an hour?
Yeah, I know everybody, I think everybody wants in.
Yes, certainly.
I know Carol probably also wants in
Yes.
too, so I don't know how we're
Maybe Carol
gonna
wants to answer.
do
Yes.
this.
Yes.
Maybe we should
Yeah.
give a little bit to Carol
Yeah,
first,
yeah.
although I know I know Danny's
I won't use much time, but I do want to say something. Thank you so much, Elizabeth, for those comments. And I do think that the language that you read about human dignity is very important. One of the things that's really interesting about the court's Eighth Amendment cases, all the way along from really the first proportionality case was Coker versus Georgia, 1977. From there, all the way through Atkins and Roper versus Simmons and Kennedy versus Louisiana, the court does the same methodology, which is quite ironic. First it says, let us look for objective evidence of societal consensus, which you contrast on one side. And it says, mostly it counts noses, how many states have done this, and has all kinds of interesting accounting methods that Wall Street could learn a lot from in terms of counting what's a societal consensus. And then it says, so we must start with objective evidence of societal consensus. But then we must bring our own judgment to bear. So it has this language. First, objective evidence of societal consensus, and then we must bring our own judgment to bear. And where does its own judgment look? The court says we look at the purposes of punishment. And if we find that those purposes are not being furthered, then the death penalty becomes merely the needless infliction of pain and therefore a violation of human dignity. Now, you might think, well, what happens if there's societal consensus in one direction and our own judgment in another direction? Fortunately for the court, it's never found them to diverge. So it always finds that objective evidence and its own judgment point in the same direction. So the court has never in the Eighth Amendment context done what Elizabeth calls for it to do, which is to say, the hell with societal consensus. Our own judgment says it's a violation of human dignity. Always, they find some way of adding up the societal consensus. I didn't get into the weeds in my paper, but they have the more recent cases where they're not death penalty cases, but they borrow the death penalty jurisprudence to declare life without possibility of parole unconstitutional for juveniles who have been convicted of any crime less than murder. And even for juvenile murderers, it's unconstitutional to have a mandatory life without parole sentence. When they declared it unconstitutional for life without parole, it turns out there's like 130 juveniles serving life without parole sentences. It's kind of not in this small numbers. So they said, oh, there are a lot of juveniles serving the sentence, but still we find a societal consensus against it because most of them are in a single state. The majority of those 130 are in Florida. So then we can say it's actually a consensus because Florida's out there, it's an outlier. This is happening with the death penalty. This is why I think if trends continue, the death penalty is becoming concentrated in only a few jurisdictions, and even within jurisdictions like Texas, only a few counties. So the methodology maps onto a way of finding societal consensus, but they've never had the courage, if you will, to rely solely. And in fact, in Hall versus Florida, the case you rely on, there's a big part of the opinion where they say the vast majority of states, and they count them up, rely on clinical definitions and clinical margins of error, standard error measurements, and therefore we say that Florida, again, can't do this because the other states aren't doing it. And then we bring our own judgment to bear. So they both do the counting, and then Justice Kennedy brings his own judgment. But I think the future, there's going to have to be some plausible way to count the numbers. But I think there will be, because they're not very strict about the math in the cases that have come, and then they can bring their own judgment to bear. So that's my thoughts.
Thank you very much. So, who wants to intervene?
Maybe I'll just briefly intervene in that. I always get a little worried when Justice Kennedy and his invocations of dignity are taken as a focal point for American constitutional development. He is somebody who and Elizabeth is quite right. This is a very interesting deployment of dignity in a variety of contexts. It is, I think, a self-consciously European deployment of dignity. And I don't know, it's a little bit of a backstory, but there's this lovely political conversation in the United States about the extent to which Kennedy has been captured by the Europeans, and I think he's been bought with conferences, dinners, and trips of some sort.
That's the story in the United States. Justice Kennedy cannot uphold his head in Frankfurt, so therefore he must decide.
And I would not want to tell any causal story about his invocation of dignity. And I think Elizabeth is right, is that with the invocation of dignity comes at least the potential for a very judicially centered locking in of societal norms. Societal norms, as even Elizabeth suggests, will need to be there before dignity is invoked. But once it's invoked, it becomes a way in which judges take control of constitutional development. Because with dignity is something that doesn't have an empirical basis. It is something that judges have, or at least can be said to have, or will claim to have a particular competence in assessing. And once dignity becomes a basis for doctrinal development, the court can prevent retrogression. That's it. Dignity does not work very well, or at least historically has not worked very well in developing the norms to begin with. It's deployed once you're there. It prevents moving backwards. But I think American courts, or the American justices, besides Kennedy, really have been wary of it. And one of the big, given that this is a comparative conference, one of the big questions I have generally is what to make of this. It's not exactly a distaste for dignity, but a reluctance to rely on dignity in not just the capital punishment area, but criminal procedure and domestic security areas in general. One could say that it is a sign of the Americans' conservatism besides Kennedy. It is a sign of a proceduralism that really has retarded American constitutional growth. Or one could turn that exactly around and say that the avoidance of judicial-centric terms like dignity have, over the past 40, 50 years in American constitutional development, allowed the courts to play a procedurally focused game that has given them a political clout, given them an ability to push rights development forward that they probably would not have had they stayed in the world of Roshan, had they stayed in the world of abstract implications that from time to time made appearances in Douglas's opinion. Douglas is not going to be a driver of American constitutional development. Kennedy will not be a driver. Kennedy's important now because he's the fifth vote. He will disappear. When he leaves, his jurisprudence will not stay. And I would not assume that somebody will be there to pick up Kennedy's mantle, both as a matter of political development in terms of who wins elections, and in terms of the durability of the jurisprudence, because there isn't any. He's a vote. He controls the language. When he leaves, the language I would not expect the language to stay. And that's why I think I'm much more tempted by Carol's story, although I still win my bet. I'll get 25 years, 30 years.
I'll take your money.
Yeah, I mean, one of the questions we have is, and that Carol raises is, we've worked at the edges on substantive regulation. We're working at intellectual disabilities, we're working at juveniles, that huge core of rape murders, or even 7/11 murders. How do we penetrate that as a matter of substantive regulation? Elizabeth has a story. I don't think it's going to be, in fact, the case, but you at least tell us a way to easily penetrate that core. And Carol, you're not quite sure, and I think you're right not to be quite sure how we're going to penetrate the core, except to say at some point, this just isn't working, let's shut down shop.
Actually, I mean, I do have a theory about exactly how the argument would go, and it just has to do with, a numbers-driven argument.
Right.
Like, I didn't play it all out in the weeds, but there is a story about how you get there, but it would be on the other side, it would be on the number side,
Right.
on the consensus side.
I'd like to, just a brief point that you mentioned about the European background of dignity. Now, that's the legend in the United States. It comes from Europe. I mean, it's a European invasion.
We never had dignity before.
No, we never had. No, this is ridiculous. I mean, this is totally untrue. Totally untrue. First of all, because there was a long heritage of protection of dignity in the common law, but also because that consideration for human dignity is the foundation of self-respect, which John Rawls, a very famous American philosopher, considers as the most important primary good. Self-esteem, self-respect, the most important primary good, says Rawls. Self-respect implies, and I'm quoting Rawls, a person's sense of his own value and a confidence in one's ability to fulfill one's intentions. That sounds furiously like Planned Parenthood, Casey, Lawrence, and so forth. Now, let's be conscious that these goals are out of reach without belief in and recognition of the inherent dignity of the human being. This is why, if you tie the abortion, if you tie the jurisprudence on death penalty if you make, a chain of all these several pieces, you end up with the idea that Kennedy will not be dead. I mean, Kennedy may be dead, but I think that Kennedy may be dead, but I think that his writings on human dignity will be
Guaranteed.
by former justices, yes.
Yes, I want to caution, and I agree with Elizabeth, but want to give a little nuance here. Dignity is a multifaceted concept, and it's a contested concept. There's no question that dignity is a very strong place in American constitutional jurisprudence, and it does so when you sort of relate dignity to autonomy. The outline First Amendment jurisprudence of the United States, exceptionalist and that goes to extremes that Europeans marvel at, is based on the idea of a dignity in the sense of self-expression. The individual should have the space to be able to establish him or herself true expression. That's one example. One also sees this, and this is referred to in the privacy rights. Griswold v. Connecticut, the dignity of marriage, decisional privacy, a whole series of cases. It's not just the idea of not being in the gaze of the other, but it's also being able to make decisions that are fundamental to how one lives one's life. So once you look at it this way, it seems to me that Kennedy is not so outlined. He does, in fact, sometimes remind one of more European approaches, and they're different. I mean, Jim Whitman has written about this. There are different conceptions of dignity, and they don't necessarily work together in the American constitutional context. But another thought that I have is Justice Ginsburg's opinion in U.S. versus Virginia about equality for women. It's based on we have to celebrate the differences, not use them against women. There is a very fundamental dignity aspect to this opinion too. So maybe a different conception of dignity, different, it's a multifaceted concept, different emphasis on the use of it. And so the question that all this raises to me, not being a criminal law person, in understanding how the death penalty, another from your paper, which we'll discuss later, other criminal law concerns seems to be filtered into procedural, so it seems to be proceduralized to death, if I can exaggerate a little bit. In fact, what does that mean? I mean, does it mean that we are trying to avoid these issues, or does it mean that we're trying to find a court that is not controversial? I don't divorce, and maybe we'll come back to this, I don't divorce necessarily procedure from substance, although it's a wonderful tool for a judge to be able to do so. But so I would caution against doing away with dignity too fast.
Yes. Well, to begin with, I mean, it's not true that the United States have death penalty. Some states of the Union have death penalty, a minority.
Yes, the federal government.
No, because
also.
in Europe there is this strange idea that America has death penalty. This is not true.
Well, the federal
America is
government
much
has-
less a unitary criminal system than the European Union. You know that you cannot join the European Union if you have that penalty. Some states who wants to join, like Turkey and Albania, had to abolish. So, but you are much more tolerant and pluralistic. So it's not true that the United States have death penalty. Some states of the Union have death penalty.
Well, there is the federal government has the death penalty, so
But the
Massachusetts.
federal government is not a reality. It's a legal
No,
structure.
but they.
You say that under federal law.
Yes,
The-
under federal law.
under federal law,
So
yeah.
there are,
Sure.
the Boston
Sure,
Marathon
sure,
bomber
yes,
is being
yes, yes.
prosecuted in Massachusetts.
No, you're right. But I
Well,
mean,
we don't
it-
have the death
yeah,
penalty, but
yeah,
the federal
yeah,
government.
yeah. The federal government has it. You're right, but some majority of the state at the state level haven't.
Yes.
So, but
But 32 states
32
have the
have
death
it,
penalty,
The
18
majority
do not.
have
The 18 states don't
32,
have it.
yes.
18 states haven't. Okay, okay.
So 33 jurisdictions have it and 18 don't, right? Something like
Yes.
that.
Yeah, but how many they enforce it?
Well, it depends on what you mean by
Yeah.
enforce.
Yeah.
California has 700 some odd people on death row.
Mm.
Most
So-
of them will die of natural causes on death row.
So
but
it's very complicated. I wanted only to say that the European sentence, America's death penalty is from far away.
Yes.
So said, the interesting point is that we are here in a case where the Constitution just says that you have not to enforce cruel and unusual punishment, which means nothing. Because we don't know what is cruel. It's not the same in the 18th century, the 19th century, the 20th century. People have different ideas. For me, almost everything is cruel. Giving a person something I cannot stand. And some other people think that killing some criminal is perfectly okay. So this is a case where it seems that the court can do whatever it wants. But this is a legal perspective, which, in my opinion, as usual, cannot explain anything. What can help us to understand? I don't want to make predictions because, as you know, predictions are difficult, notably concerning the future. So I want to speak about the past. Predictions about the past are a bit easier.
Much easier.
So if you look at the data of Gallup, and I have a photocopy here particularly, that helps us to understand a lot. As you, Carol, said, there was one period where the court could decide that cruel means killing. Cruel means whatever. But at some point they said when there was a majority of the American public opinion saying that killing was cruel. Then, for reason that sociology has to tell us, political sociology, the American mind changed. And in the 80s, 70%, you have the numbers, decided that killing criminals was wonderful. It was not cruel at all. And then the court has to go back. It could not resist such a huge position in the public opinion. What is interesting is that apparently the Congress is very democratic in the sense that it follows the public opinion. So the court had against the possibility of abolishing penalty not only the public opinion but also the Congress, which takes very serious public opinion because they want to be re-elected. So it's very difficult that what you suggest, and I totally agree with you on a normative point of view, that the president will now say, I want to abolish that penalty, he will lose the election. So it cannot help the abolishment of that penalty because he loses. You have to win first to do something. If you lose, you cannot do anything. This is politics. It's not law, but you don't understand law without politics. I'm sorry, but that seems to be the reality. Now, in the United States, there is this homogeneity, so to speak, between the representative and public opinion, much more than elsewhere. For instance, in South Africa, the Constitutional Court abolished that penalty some years ago, notwithstanding the fact that the public opinion was in favor, but the Congress, the Parliament, was with the court. So if there is a conflict between representative and the public opinion, the court may have a room of decision. If they are very similar, the court cannot go against. It's too dangerous. And I want to finish saying that probably what you call procedures was the way for the court to do something without doing too much. It's true that procedure and substance are the same, but not in the legal language. In the legal language, you can play with that and say, well, we're not speaking about that penalty, we're speaking of due process. Well, due process is very important in this country. We don't care about life and death. We care about due process. So it was a smart move until the public opinion said, you guys, no, you cannot do that because you are not free to interpret the Constitution as you want. It's true that the Constitution doesn't say anything. This is a typical case. It's empty. But there is more than the Constitution as a constraint upon the courts. I think that slowly this difference between those in favor and those against is reducing. So maybe if it reduced a bit more, it makes things easier. What happened in France, by the way?
Yes.
It will be very interesting to compare this story with I have the data for France, but it's not important. So
I just wanted to point out one interesting political point. I don't know if you noticed this, perhaps the death penalty people noticed, but just a few months ago we had a problem with some botched executions where the lethal injection and terrible pain. And for the first time ever, President Obama, a sitting president, said, to give a press conference and said, I'm very concerned about this, and this raises questions not only about execution protocols, about lethal injection, but about the death penalty more generally, and I'm going to instruct my Attorney General to investigate problems with the death penalty, including discrimination in its administration.
he's not up for re-election.
He's not, but this is the first time, he still has an interest in his political capital.
Party, well, no.
But it's the first time a sitting president ever
Yeah.
has questioned the death penalty. I mean, think back to the mid-'80s where presidential candidate Michael Dukakis, in a televised debate with him and George H.W. Bush in 1988, on television, Dukakis was asked, you know, he was from Massachusetts, he was on the record against the death penalty. They say, Governor Dukakis, you say you're against the death penalty. What would your reaction be if your wife, Kitty, were raped and murdered? And he said, blah, 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 human dignity, I'd be against it. He was, you know, destroyed in the election. So much so that the next election, Bill Clinton took time from his campaign to go back to Arkansas, where he was the governor, to preside over the execution of a mentally disabled man, to show his support for the death penalty. So we have come from the 80s and early 90s, you know, not just on that chart, but the idea that a president would give a press conference saying anything critical about capital punishment.
Now, a woman may do it.
Yes.
Maybe.
I think that Elizabeth is really thinking of somebody.
Yes.
But I think, you can see like Obama is, in his words, evolving. You know, he evolved on gay marriage and now he's evolving on capital punishment. So the politics are so interesting because, you know, you look back to the 80s and 90s to today, there's big changes, I think.
Okay, Bernard, want to
Yeah,
take the
a few
floor?
quick little-
And-
oh.
and- yes, go ahead.
Are we out of time or something?
Keep going.
We have
No,
10
okay, we'll just
minutes,
go-
and
yeah.
then we'll
I'll
start.
give
quick
them
punctual
four
points. Yeah, I'll
comments.
take this out of my time. Punctual points. And most death penalty people know these numbers, and I'm sure Carrie hasn't. But when you put the option of life imprisonment without parole, I think that the numbers are under the majority.
They're a little over a majority. If you put life imprisonment without parole while the defendant works for restitution for the victim's family while in prison, then they go under 50%.
They go under. Okay, but so there might be some there might be some political play that can be worked there. In other words, it could be the case that we're practically. I mean, a smart leader could potentially present it in a way that would actually capture a majority of the opinion, just as. And as I'm actually on record saying abolition in 2050,
You are?
right? So that's where I stand, which is a little bit less optimistic. But on a rationale of the kind of objective counting of number of states that are abolishing, and so we've seen that recently. It continues going up. The number of executions going down, the number of sentences being meted out going down, etc. So all of the indicators that could be used in the kind of Atkins or the kind of juvenile case logic, again, where the numbers are somewhat cooked, could be baked in the death penalty context over the next decades, I would think. I did want to intervene on the Kennedy and the human dignity and the question of whether he's captured by a European audience. I think
That
that's
wasn't
right.
my claim.
I think that's right. Well, but I think
It is
I
the
think
scurrilous.
but I think it's right to a certain extent. I mean, I think the language is remarkable in that opinion, the number of times he's using the notion of dignity. And I think it does, I mean, even though it is part of an American tradition, I agree, and actually I can flag this as the question of the relationship between the notion of dignity and a certain form of humanism in the 1960s or 70s, because when you were talking about autonomy, it's really this idea of humanism, I think, that we had in mind, and I'll flag that for later. But I do think that Kennedy is pointing to drawing support from the European notion of dignity discursively, whether one likes dignity or not. I know we have a lot of dignity skeptics in this room too. But discursively, he is drawing on an authoritative tradition that could be somewhat contagious. So so I could imagine Sotomayor or some of the other justices going down a vein of dignity. I mean, it does allow for an intervention that wouldn't be allowed for as easily under the notions even of our own judgment, the second prong.
Mm-hmm.
So I'm not sure. I could see it catching among some of the other liberal justices in greater conversation with a more cosmopolitan, European-focused decisional context. I did think, Elizabeth, that the notion of proportionality, though, is the word proportionality is a fig leaf in this business.
It's a what?
And a fig leaf, and
Do you say that in French?
feuille de vigne, is that what it is?
Yeah, feuille de
Okay.
vigne.
So yeah. So while I did notice, like on page 21 of Carol's draft, that she does refer to proportionality jurisprudence and the question of proportionality, that is not. It's not really a notion of proportionality. It's really just the notion of evolving standards of human decency that get kind of that are called proportionality. So just the focus shouldn't be, I think, on whether proportionality would work, but just whether that vehicle of evolving standards would work. And then two quick thoughts, Carol, on the paper, which I really enjoyed, as I did yours, Elizabeth, too. Actually, that was a thought on your paper, Elizabeth. On the first, substantive versus procedure, I have two thoughts. One is that on the bottom of page 8, you make this claim that actually the Supreme Court, unlike legislators or administrators, decides specific issues in the context of cases. And so there's this idea that part of the substance procedure interplay or constant kind of tension and back and forth is the product of not having a fully capacious regulatory take on, the death penalty. So it's not as if the Supreme Court can say, we're going to create a death penalty that has this, that, the other. And I don't know whether I agree with that in the sense that, I see very often the same kind of procedure versus substance backlash and play within Congress, right? And so Congress comes up with the anti-terrorism death penalty in '96 or whatever that was, which is supposed to re-regulate the whole sphere, and part of it's procedural, part of it I suppose we could think of as substantive, although it's mostly procedural. But in any event, it's even there you get exactly the same kind of. It's almost as if it's an inevitable tension. That is okay. So
Just
that's not.
heightened because when you're only making a judgment, you can be on any grounds. Whereas if you're intervening, you have to have a reason why you're doing procedure as opposed to substance.
Right. Okay.
I agree.
Yeah.
It's a general regulatory problem.
Right. Yeah. Okay. So the question might then be whether it's more heightened in the case of the Supreme
That's
Court or not. Yeah. Okay.
I think you're told with your intervention.
And then finally, the last point I was thinking in that context also was the relationship to liberalism, and so it's not in here, but I think it is, or it's between the lines. But and this is a bit kind of the Rawlsian which we were talking about earlier. That notion that we would fix the procedures only and not deal with the kind of substantive outcomes is a perfect replication of liberal theory, right? The idea that we're not going to make judgments about what is right. We're just going to establish some rights. And I think there's something interesting there.
Yeah.
It strikes me, because theoretically, a liberal legalist could argue that that is exactly what we need to do. Right? We need to create a right to counsel. We need to create a right to be free from unreasonable searches and seizures in some strong way, and then damn the outcomes. Right? If Texas wants to execute 600 people, that's their vision. That's their political vision of the good that is produced.
That's interesting. Yes, I like it.
And it's not clear that you can get traction into that from the substantive versus procedure, because maybe it is a theoretical structure that is intended to let people have the outcomes that they're going to have, including lots of executions, if that's what they want. You know what I mean? So there's something in there that, in a sense,
it.
almost undermines the, yeah.
Because it
But
takes
this
some
is-
explaining why this strong pull toward proceduralism.
The hallmark of
Fits.
liberalism, I totally agree
It
with
fits,
Bernard.
right? I
Does
mean,
it?
it fits
I
with the
mean, we do
political
have
vision
substantive
of-
regulation. We do have, Atkins, Grover, Kennedy.
Yeah, but that is not, it does not go deep,
Right,
the
it's the
substance,
center.
it stays on the procedural level. But this is so true that what Bernard said, that in liberal constitutionalism, procedures are all what called for. I mean, if you read, for instance, this famous Article 16 of the French Declaration of Human Rights and of the rights of men and the citizen, toute société dans laquelle la séparation des pouvoirs n'est pas assurée, ni la garantie des droits. But the problem is whether these are two prerequisites in separation of powers and guarantee of rights. Is that one single problem, or are these two different problems, two different questions? Many people would argue that all that you need is to have separation of powers. And this is the quintessential liberal approach to constitutionalism. This is why, in fact, Hamilton, in the Federalist Letter 84, stands on the position that what the hell do we need? Do we need a Declaration of Rights? Why the hell do we need a Bill of Rights? We have all what we need with procedures. We have separated powers. We have a pristine legal process. That's all what we need. We don't need more. And as you know, this is totally, impossible for a French person. On the contrary, we do operate on the complete reverse. We have to declare the rights to found the society, the social basis, and then build up on the political foundations. Build up on the political structure.
Give me two small points. The first one on proportionality, because there is and I understand it's very little, picking up on Pasquale's point, but the Eighth Amendment jurisprudence says that something has to be grossly disproportionate to be cruel and unusual.
Mm-hmm.
So we do have an official proportionality standard, though it's extremely loose. That's point number one.
And different in the non-capital context. So
The standard is the same. The question is what counts or doesn't count as grossly disproportionate.
And nothing counts outside the non-capital area.
Nothing counts except there are cases, like the three strikes you're out case, where
Now
the
the
court says
juvenile
this is
law
not
case.
grossly
And that's
disproportionate.
the-
So I mean, you can be critical of this and say, in effect, anything goes, but I mean,
Right.
in theory, formally, there is something.
But the only point I wanted to make was that the court uses a different method for determining that in the capital context than it does.
Oh, yeah,
in
yeah,
the
yeah, absolutely.
non-capital.
Yeah, no, I agree with that.
Now it says it's not a capital, non-capital distinction anymore in Graham and Miller in these juvenile LWAP. Justice Kennedy again.
Right, he's,
It proves the point that it's very vague, but it's the second point though, and here I feel very strongly, come back to substance and procedure, and it picks up on what you're saying. Yes, they didn't need a Bill of Rights because they were Lockean, they're natural rights. There's the notion of property, there is the libertarian view. Procedural rights will do it because otherwise we take care of ourselves. So when you have a situation in which the substance is non-controversial, or you want to make it non-controversial, you want to make it invisible,
Right.
then you focus on procedure and say
Yes.
that's the only thing that matters.
Right.
I want to offer, and I'm totally out of the field, so this may be completely wild, but there is, in my reading of as a complete outsider, amateur layman, of the death penalty jurisprudence, the following. In fact, we want the death penalty for some very specific things. Most of them happen to be racist or happen to be, they sort of speak to parts of our collective conscience that are not, that if we sort of laid them out, we might not be that proud of. And focusing on the procedures is a way in which, number one, we don't talk about that. I mean, why do we want the death penalty? I mean, if a banker's son happens to kill a young prostitute, we don't want the death penalty. But we are very much also in the statistics that they're not only direct prejudice against African Americans, but the killing of a white person is more likely to get the death penalty than the killing of a non-white person. So when you put all this together, the American fears and projections as to why they need to be protected by the death penalty is often associated with things that are not that nice. And when you focus on procedure and you only say, okay, it has a double edge advantage. One is you're not looking at the substance, but the other one is, what do you mean it's unfair towards African Americans? If the jury considers A, B, and C as an African American, then that doesn't count. We have to make sure that they do X, Y, and Z. So you somehow get the roughest edges out, and you shift the focus. This is why I get little concerned when I hear that substance and procedure are, sure they are formally when the court focuses on this and that, or right to counsel means X, Y, and Z, but we should always look at the other side. Why is it so important to focus on procedure apparently in the abstract?
Yes, a very, very short point. It's mostly a question to Elizabeth. I enjoyed both papers, but I was puzzled by something that you said. There's a distinction between proportionality, that would be a societal fact, and dignity, that would be an ethical standard. And I'm a little puzzled by that, because first of all, proportionality is a balancing means towards an end. And so when you do that balancing, so you obviously have ethical standards to operate that. Is the end valuable, and are the means valuable? And then you do that balancing, so it's an ethical judgment as well. So it's only a question of fact when you take the point of view of a court that would look at public opinion and look at the balancing that public opinion does. So it's only a question of fact from that point of view. But the balancing done by the public is itself an ethical judgment. So this is the first one. But then assessing a fact is also a decision by a court. And the decision by a court is done for ethical reasons. So it's not just photographing public opinion and looking at it through a Gallup poll. It's also deciding what counts as public opinion. And that's also an ethical judgment. Now, about dignity, of course, it's an ethical decision, but it's a decision by a court that will, and the court will decide for all sorts of reasons that may be ethical or not ethical when deciding on dignity. So both, so my point would be that in both cases you have not fact and law, but you have law on both sides, and on both sides
Agreed.
you have a decision.
But when the court, I mean, looks at the age of the criminals or at the disability, mental disability, I mean, that's not law. That's
Yes.
not questions of law.
No, but the decision that you make about
Yes.
the age and about the disability, that is law.
Sure, it's law, but the proportionality, I mean, the reason why I said that has to do with the substance, the place of proportionality in German jurisprudence. Because proportionality comes from German jurisprudence, and it was resorted to by the judges because at some point in the analysis of facts, you need to compare certain factual situations, and this is all what proportionality review is in, for instance, administrative law.
Yes, but this is precisely my point.
Yeah.
That
But
the judgment
in
you
my-
make on facts
in my opinion,
is
you
an
do
ethical
not
judgment.
put dignity in balance with other values, because dignity is an absolute. Human dignity is an absolute. It's a fundamental right. Otherwise, I mean, I do not see if you put, I mean, ethical values in balance, then this is the end of the story. I mean, in the German Constitution, for instance, as you know perfectly well, and I think everybody knows here, that human dignity stands out. I mean, in the German Grundgesetz, I mean, it's considered as a fundamental value and cannot be derogated from under any circumstance, right? But yes, this is precisely the point. It cannot be derogated from under any circumstance. It cannot be put in balance with something else. And this is why I think that I totally agree that there is a proportionality analysis in the death penalty case of Carol is absolutely right on that score. I did not question at all. But I don't think that the same level of analysis. I don't think that human dignity is something that you put in balance. It's an absolute. It's an absolute. It's the same thing as equality of rights between whites and blacks. It's exactly the same thing.
But
I mean, it's the same approach. It's the same approach.
no,
wants to
not
answer.
at all. But Elizabeth, I would say, especially the human dignity in the German Constitution and the jurisprudence of the Constitutional Court. Of course, human dignity is always put in balance. For example, one of the last years where I discussed discussion of the court about torture. When you have the kidnapper in the police office, and you know that the kidnapper knows where the kidnapped is, and so you have two values, two constitutional values, two dignities, if you want so, to put in balance the life of the kid or the dignity of the kidnapper to not be tortured. So you have always, so dignity is a sort of magic tool.
But that's
You
precisely
can-
the point. I mean, you're not going to
And-
torture, I mean, the kidnapper to get the truth. Because you do
this is,
respect.
but you know very well this is, this is the question. Huh? I don't know. I'm
This
not,
is for
I'm
me,
not-
but for
Yeah,
me,
but
this
this
is
is-
not the question precisely.
Yeah, but this is the question.
Otherwise,
and,
I mean, dignity
and if
becomes
you
an
and
empty
if you
word.
and if you look at the death penalty, dignity is a sword with two sides, if you want so. Because what is the alternative of death penalty? The alternative would be, I assume, the life imprisonment. As you know, in the German constitutional jurisprudence, life imprisonment is contrary on human dignity. Huh?
Yes.
So that's for because that's the reason why in Germany usually people are only 15 years in prison. Huh? So the alternative to death penalty is also on the contrary, in the case of the United States, would also be on the contrary of human dignity. So if I would be in favor of death penalty, I would say death penalty is perfectly adequate with human dignity, because it's much better to kill someone than to put him 50 years
But the
in
human
juvenile
being
case
cannot
or
be
60
taken as a
years
means.
in jail. Huh? And the only thing is we should shorten the time on death row. That means we kill him immediately, more or less. Huh? So as in the 19th century. So that would be much more deep. So you know, I'm not in favor of it. Don't worry about it. But but all these are legal questions. This is legal reasoning. This is interpretation, huh? And this is the fight of especially of balancing two possibilities to treat people like this. Huh? And I must say, on the certain, Florence is president of the World Coalition Against Death Penalty, but I must say that from a certain point of view, death penalty is much better than life in prison.
Thank you very much, Rainer, for this fantastic defense of our
Plenary.
position. So now we have a slight problem. It's a quarter to noon. I think that Carol wants to answer, Olivier wants to make a point. I would like to say something. I'm very sorry. I would like to speak 5 minutes on that topic.
So we're okay with time.
No, we are
can
not
do
okay.
this really
I'm
quickly.
short in mine.
No. But
Okay.
our only constraint is that you have to go do a defense,
Yes,
and I'll
at
take
1 o'clock.
over.
Yes,
Yeah,
exactly.
I'll
You
take over at
Okay,
1.
that's perfect.
And when we get hungry, there's food that's going to be here.
Okay.
So we don't really have
And there is water
strict
here for
time constraints. So why don't we finish
We will
this
not
conversation?
That's fine.
We can. Why don't we finish this conversation and then take a little break for anyone who needs to get a cup of coffee, which there should be some outside, hopefully. But so 1, 2, 3.
I just wanted to build on this idea of dignity as having, as requiring balancing of other interests, because your friend Justice Kennedy has invoked dignity in the abortion context, not on behalf of the dignity and autonomy of the mother, but on the dignity of the fetus.
Absolutely.
So in the abortion
Yes.
context, you see, and so Reva Siegel at Yale has been an anti-dignity
And Linda,
intervention, yes, because of the squishiness of dignity. There's the dignity of the fetus and the dignity of the mother. There's the indignity of capital punishment and the indignity of life imprisonment. And in the criminal context, I have to say, there's the dignity of the victim of crime, and that some offenses may demand a kind of proportional punishment. This is the leading argument in favor of the death penalty in the United States, because nothing else adequately responds to the dignity violation of the individual victim. So dignity has this quality, particularly in the area of criminal justice, where it can be invoked on both sides of the equation. So that's, you can see in our own jurisprudence how that happens. It complicates the, robust call for we need more dignity, because it's unclear where it would lead us.
If I can add, the great German philosopher Kant said that the death penalty is the only way in which the killer
Yes.
can achieve dignity, because otherwise
To be
there
executed.
is a sort of a moral
Exactly.
vacuum.
Categorical
That-
imperative.
Absolutely. So.
Yeah, but it seems to me that Elizabeth is saying
I think
something
that
completely
Olivier wanted
different.
to say
Sorry.
something.
Yeah, so I mean, you are speaking against
Olivier wanted to
someone
say
who doesn't
something.
exist.
I'm sorry because I'm alone to speak in French and it's too difficult to speak in English. Je veux juste 3 secondes dire que je suis très heureux que la conversation s'attarde sur la question de la dignité et du rôle que ce concept joue dans le droit contemporain, le droit constitutionnel, aussi bien en Europe qu'en France qu'aux États-Unis. Et ce que j'observe simplement, c'est qu'il y a les mêmes discussions qui reviennent sans cesse sur la question de savoir quel est le contenu qu'on doit donner à la notion, comment on doit tout bonnement qualifier en termes de dignité Ce qui me semble, c'est ce que dit Elisabeth, c'est que peu importe finalement ce qui apparaît comme étant non conforme à la dignité, mais c'est simplement l'argument de la dignité qui est susceptible d'être efficace. Le fait d'argumenter en termes de dignité, probablement, et on peut l'observer, qui le mieux dans les développements de la notion en droit français. On n'arrête pas d'invoquer l'argument de la dignité, quelle que soit la décision qu'il s'agit de prendre. Et on a beau, quand on est juriste, comme le fait le Conseil d'État, revenir sur son propre emballement à propos de la dignité. Le Conseil d'État était le principal promoteur de la notion des fameux arrêts sur le Sénat. Et puis 20 ans ou 15 ans plus tard, dans une consultation, il dit à propos de la loi anti-burqa qu'il convient de faire attention à ne pas utiliser le concept parce qu'il prête en fait à discussion. Ça n'empêche pas, en réalité, les promoteurs de la loi anti-burqa de continuer d'invoquer le concept pour dire que c'est ce qui explique la raison pour laquelle on demande aux femmes de ne pas porter la burqa. Et on va voir ce que la Cour européenne des droits de l'homme demain aura à dire sur le sujet. Donc,
c'est demain.
Oui, oui.
C'est demain qui descend.
C'est demain.
Qui tranche.
Et donc, ce que je pense, c'est que la dignité, moi je suis de l'avis de Reiner, je pense que c'est plus une sorte d'abracadabra qu'autre chose, mais ça a moins le mérite d'effectivement qu'on veut produire des effets.
Okay, some short remarks. So first on this, first on factual things. Pasquale, I really don't think that it's a view from Europe to say that America or United States are retentionists. Well, first we gave the figures, and second, it's they are on the top of the 5 most executioners in the world. So that's a pure fact. Okay. So that's one point. A second point on the poll you gave about life with a parole. I think that one very good test was in California, where in 2012 there was a big poll on do you want to replace death penalty by life without parole, and it did not pass. It was 48 in favor, 52 against. So of course, if you ask the people are less in favor of the death penalty if we replace it by life imprisonment without parole, but still only 48 were in favor of replacing. On human dignity, I agree with what you said. Also with what Michel said about the fact that even proportionality is illegal. It's adjudication, so it's legal. But what I wanted to say is it depends on the context, and I think that in the case you mentioned, I think it was very interesting to refer to this human dignity principle because there is all. Correct me if I'm wrong, but. In the US, about people who are on death row, there is all this rhetoric on they are the worst of the worst. So I think it is. I mean, it's a matter of criminology. It's important to say that even the worst of the worst have inherently a human dignity, and that they don't. So I think it's also. Based on the context, it's in the public opinion. I think it's important to have that. And last, on human dignity, I don't think it's a matter of European versus the US. It's also an international standard matter. And more and more, US Supreme Court decisions on death penalty only speak about death penalty because it's the only thing I know a little bit. Refer to international standards. In the Atkin case, they refer to international standards. It was really a turning point. So I don't think it's a European versus United States perspective. It's also a matter of international standards. So that's what about human dignity. About substantive and procedural, I thought that the Georgia Furman versus Georgia case was procedural. I mean, the United States, the Supreme Court said you cannot implement death penalty laws as you do. So change your laws, and then it will be okay. So I didn't know that the U.S. Supreme Court thought that they will abolish So I thought that in their mind in '72 they had the impression that okay, we put the story on a substantive issue, so we'll see how people will react. But I had not the impression that you say that it's something else which is written in that book.
And the papers of the justices who are on the court now are available, and it's quite clear that the two key justices thought, Stewart and White, who were the two key who wrote the procedural parts, that their discussions with each other, it was clear they thought this was going to be the end.
There is, if I may add, a very brief thing here, a comparative constitutional point. When you read the South African Constitutional Court decision, there the Constitution left it open for the court to decide whether or not South Africa should have a death penalty. They looked at the United States and said the inherent racism that was surrounding the death penalty, this is 1994 or 5, I think, the South African decision. The inherent racism found in the United States context advises us against adopting the death penalty, which I think bridges the gap between substance and procedure. We have a mindset like the Americans. We have a history of racism, and so you can't really be confident that if you adopt the death penalty, you will avoid this racist tint to it. So, I mean, it's easy to go from there to say that dignity requires to abolish the death penalty. We have a history where we've used the death penalty, but it has been unfair inherently because it was racially tainted. And so I think that there's a continuum there. It's not a bright line.
And what I wanted to add on that point is that substantive perspective is really the one which is used by activists in an international context, because we perfectly know that we cannot tackle with moral or political. I mean, it's much more easier to tackle with procedure than substantive issues. It's much more easier to say it doesn't respect due process, it doesn't respect, rather than saying just it's wrong. And it's a pity. It's like that. It's tactical. And last point, why, since I'm here with so many prominent constitutional specialists, why in the US cannot we simply argue that death penalty is contrary to equality? It's something I really cannot understand, because 2% of the counties are responsible for 90% of the death penalty sentences. 2% of the counties in the United States. It's something incredible. So it's really something that I cannot understand.
One thing that it's very hard to get across into an international audience is how hardwired county-based criminal justice is in the United States. And this is not just a matter of the death penalty. We talk about state systems. There aren't really state systems. There are county systems. And one of the real weirdnesses of the American criminal justice system is that the states are passing criminal statutes. The states are paying for prisons. Then they essentially are licensing the buying, the provision of criminal justice to elected judges and elected district attorneys. And that's not federal constitutional law. That's not even, in many cases, doesn't have to be state constitutional law, but it is so much a part of the way we think about criminal justice in the United States that, just to sort of turn your question around, the durability and resilience of those norms are probably more developed than that of equality, which has it's not ethereal. We actually we instantiate equality in so many different ways across different doctrinal spaces, but it is an incommensurate with this choice of criminal justice to be done at the county level, and you can't do the math. There's no, equality versus county criminal justice. There's no intellectual justification. It's pure path dependence.
I was going to say, like Pasquale was talking about how states have the death penalty. States don't have the death penalty. Even in Texas, Texas has 240 some odd counties. More than 200 of them have not executed anyone in 20 years. So the death penalty is not a Texas institution. It's a Houston, Dallas County institution. So it's so striking.
I think there's an added constitutional point to this. I had this discussion many years ago with Louis Favoreux, the French people who know, is a great French constitutionalist, and he could not understand. And there are two things, that outside of the United States, equality law is national, and whereas we have an equal protection clause that says that every state has to treat people equally, but Virginia can have a law that gives twice as many years in jail for stealing than North Carolina. That's not unconstitutional. And the second part, which is in many federal systems, I think perhaps most federal systems, criminal law is nationalized, whereas in the United States, it's practiced countywide, but it's statewide in terms of so the notion of equality, even if you translate it to pure constitutional argument, without looking at the social and the practices of the legal establishment, don't correspond to European, certainly not to French ideas, and certainly not to European ideas of the subject.
Okay, I think that everyone
That
needs
was
a cup
great.
of coffee.
Okay,
A cup
thank
of-
you.
So much.
And there are restrooms on this floor, just out straight and left.
Also a